Well, thank you everyone for coming. As you know, we had a bit of a change of schedule, but the topic is somewhat similar. We're still talking about the rule of law today,
Absolutely, yeah.
and that's good. So we are very happy to have you here, Professor Emad Atiq, who's professor of law and philosophy at Cornell University, both law school and the School of Philosophy, is joining us today to present the paper "The Law, the Rule of Law, and Goodness Fixing Kinds." So, because there was very little notice about this session's paper, the presentation will be slightly longer, so it'll be around 45 minutes, and then we'll have the Q&A, and hopefully we'll have a great discussion then. So the floor is
Great.
yours.
So I'll start by thanking Javier and the jurisprudence group for inviting me, even though it was a last minute invitation. It was excellent timing because I received Javier's email halfway through dinner at Cambridge, a high table dinner. I'd had several glasses of wine, and I said, sure, this sounds great. Just give the talk that I just gave at Cambridge, not realizing, of course, or underestimating the effects of both the wine and the jet lag the next day. So if I'm cognitively compromised, that's sort of a caveat emptor and an apology in advance. But thank you. So I'm very happy to be here, and I look forward to your questions. My talk today is about the ideal of the rule of law, a set of characteristics that good laws and good legal systems are supposed to instantiate. But unlike Carmen, who I'm sort of subbing in for, I won't be doing first order ethics or normative theory. That is, I won't be fleshing out this ideal. I don't have any new insights to offer about the ingredients of the rule of law or law's good making features. Um, I'll mostly be taking the ideal of the rule of law for granted, or what people have historically said about the ideal for granted. And I'll be asking what it reveals about the nature of law, that law is evaluable in terms of this ideal. And more broadly, I'm not even just interested in the metaphysics of law for the purposes of this talk. I'm interested in the way that our talk of law and legal goodness is situated within a larger conceptual framework involving evaluation of kinds. Right? So, given the same, it might be helpful to start with a general observation about evaluation. Hopefully an uncontroversial observation. So we evaluate things as good or bad, better or worse relative to different criteria. Um, a knife, say, might be evaluated for how well it cuts things, its beauty, its cost, where it was made, and a range of other features. But sometimes the criteria we use to evaluate things seem non-accidentally connected to the kind of thing it is. In the case of knives, it's natural to think that the better a knife is at cutting things, the better it is qua knife, as a knife. Any analogous claim about the knife's beauty or its cost would seem artificial or confused. And we mark this distinction in ordinary language in several different ways. So when we wish to indicate that the criteria of evaluation are kind relative, we employ the idiom of being good as a K or qua K. And in fact, the linguistic resources available to us for this purpose to mark this distinction are really quite rich in ways I think that aren't sufficiently well appreciated. So you might say K's insofar as they're K's are better if they're G. Seems like a natural thing to say. K's as such ought to be G. In as much as something is a K, it is to some extent G. What is K is to that extent, and so on. So the linguistic resources for marking this distinction seem really quite rich, which suggests that we're trying to say something interesting. There's something distinctive that we want to be able to say. Another way we mark this distinction is by employing kind relative evaluative criteria in our modal and classificatory judgments associated with a kind. So, for instance, it's extremely tempting to think that in order for an object to be a knife, it must be to some extent good at cutting things. That seems intuitive. Moreover, being able to cut things well, it seems, would make a knife good as a knife, at least qua knife, in any possible situation in which you find knives. Right? Whereas it needn't make the knife good, all things considered, or in some kind independent sense, maybe a moral sense. So Judy Thompson famously refers to such kinds as goodness fixing, whose nature, she argues, fixes a restricted, crucially, a restricted standard for evaluating instances are better or worse, as better or worse. Um, and she observes rightly that not all kinds are goodness fixing. It makes little sense to ask what makes a rock good as a rock. And the same goes for colors, for prime numbers, for sets, collections. But we can easily multiply ordinary examples of goodness fixing kinds. Um, Consider hearts, livers, houses, clocks, knives, and so on. Poems. And these examples, as I'm illustrating, can be drawn from a broad range of different domains. You can draw them from the natural, the biological, the artifactual, and the aesthetic domains. And given this fact, some philosophers, including Thompson, think that understanding such kinds, understanding why they're goodness fixing, and what makes them goodness fixing, is the key to understanding normativity and evaluation more broadly. But we needn't and probably shouldn't go that far. What's relevant for our purposes is the extraordinary consensus within legal philosophy that law is a goodness fixing kind. I say it's extraordinary because I'm sure we all know this. Legal philosophers tend not to agree about much. Right? Indeed, legal philosophy has been marked by stark disagreements about pretty much every aspect of law: its essence, its fundamental nature, its grounds, its relationship to other normative systems. But when it comes to the idea that laws can be better or worse qua laws, there is a surprising amount of agreement. Legal positivists, natural law theorists, and non positivists more broadly, folks who disagree quite deeply, strongly about the nature of law, all seem to embrace what I shall call the rule of law thesis, and it's on page 1 of your handout. The thesis states that laws are governed by certain evaluative norms. That is, they can be evaluated as better or worse based on certain characteristics simply in virtue of being law. Now, philosophers, theorists of the rule of law have disagreed about the precise characteristics that are constitutively good making. If Carmen was giving the talk today, she would have identified how much they've disagreed, how widely they've disagreed. But they haven't disagreed about some of the characteristics. They haven't disagreed that there are some such characteristics, some kind relative good making features. And the ones that are widely regarded as kind relative virtues, I'm going to use kind relative virtue and constitutive virtue interchangeably. So the ones that are widely regarded as constitutive virtues of law include clarity, right? Whether a law's content is clear; generality, whether a law applies to groups of peoples and situations generally rather than named individuals, say, in one-off situations; publicity, both in terms of the content of the law and the reasons for its implementation; and non-retroactivity, the idea that a law shouldn't apply to events that occurred prior to its enactment. I have some quotes on page 1 of the handout that are meant to be illustrative of this apparent consensus. I won't read all of them. You guys can read them, but just for illustrative purposes, Joseph Raz writes that the rule of law consists of a set of characteristics that together represent the specific virtue of the law as law, a universal doctrine applying to all legal systems. Likewise, Matt Kramer, I don't have the quote on the page, uh, observes that minimal conformity to the rule of law virtues is necessary for the existence of a legal system, and moreover, that the rule of law also defines an aspirational ideal for all legal systems, though he's recently contested in conversation second bit that I'm attributing to. But he's on record. I have the evidence of that proves that he has said it, at least, that the rule of law also defines an aspirational ideal for all legal systems. Notice the modal claims, right? These are modal claims associated with the ideal that are markers of kind relative evaluation. Such claims, far from being idiosyncratic or overly philosophical, find expression in ordinary legal practice. So in some of my prior work, I've tried to show that for much of legal history, ordinary jurists have treated the proposition that laws ought to conform to certain norms, certain principles, simply in virtue of being law, as a platitude, indeed as self-evident. There were these famous principles of legality that used to be articulated at the start of these introductory legal texts, treated as sort of axiomatic. And what I find really quite surprising, insofar as it frustrates some of my armchair expectations, is some recent experimental work conducted by Ralph Donaldson and others that suggests that even lay people think of law in such terms. That is, they consider some features of law highlighted by Raz and others like generality and publicity to be in some sense essential to the law, in that all law ought to instantiate the relevant features to some extent, even though actual laws routinely violate these features. And that's really surprising because, at least in my mind, because I didn't think that law's status as goodness fixing was all that obvious. I think you can argue for the claim, and I think that philosophers who've endorsed this thesis are onto something. But it's really quite surprising that even lay people, folks who haven't really spent much time thinking about philosophy of law or aren't trained in the law, think in these terms. It's really quite remarkable. So the rule of law thesis, understood minimally as a thesis that laws can be evaluated as laws, comes as close to common ground as we find anywhere in legal philosophy, and that's, I think, what makes it an excellent place to start theorizing about the law, to start doing jurisprudence. Indeed, this consensus sets up the fundamental question that I want to raise in this talk, which is, why does it hold? uh, it's widely accepted, this thesis, but it's not entirely clear why it should hold. It isn't clear why law's nature should entail any constitutive norms of evaluation at all, given that there are plenty of things that aren't subject to these norms, such norms. Right? I gave some examples earlier, like rocks, and numbers, and colors, and sets and collections. Neither is it clear why law's nature should render some specific characteristic, generality, say, a constitutive virtue of law. So we can ask the general question, why are there any kind relative norms at all? And we can ask about specific characteristics that have been regarded as constitutive virtues, why they're constitutive virtues. And such questions warrant our attention, I think, because, as I'm going to argue next, the leading explanation, the leading answer in the philosophy of law, judged by how widely it's discussed, and the Stanford Encyclopedia of Philosophy article on the rule of law, sets our talk of law's constitutive virtues oddly apart from our kind relative evaluation generally, and our talk of kind relative goodness. It treats law as sort of strangely exceptional. More specifically, I'll argue that Raz's explanation violates general principles of modality, explanation, persistence, and existence that plausibly govern goodness fixing kinds. And that's the set of issues that I want to turn to next. I should say the overall argument that I'll be delivering today has a negative component and a positive component. So I'll start by critiquing what I take to be the leading explanation of the rule of law. And then I'll develop an alternative that is animated by the goal of preserving continuity across goodness fixing kinds. I'll try to convince you that we can give a more continuous explanation. So we're now on section 2 of the handout, on page 2, on Raz's exceptional explanation. So Raz, like most philosophers writing in this area, includes clarity, stability, non-retroactivity, publicity, all of the standard features as core rule of law virtues, but he allows that there may be others. Right? He leaves open the possibility that there may be other non-obvious kind relative virtues. What's relevant for our purposes is his claim that the reason these features are the specific virtues of law as law, the virtues, I'll just quote him actually, that might be better. The specific virtues are ideals that laws should conform to. The reason they're the specific virtues that laws should conform to is that their instantiation, quote, protects us from wrongs for which the law's existence creates opportunities. Put differently, law, when it conforms to the rule of law virtues, minimizes a danger created by the law itself. The precise danger is that of arbitrary government, which Raz defines in explicitly normative terms as the use of power that's indifferent to the proper reasons for which power should be used. Okay, so we can start in a concessive spirit. For present purposes, we can grant that law's existence uniquely entails a risk of abuse of power, though the existence of various non-legal institutions might entail similar risks. Like consider religious institutions, right, and the social rules that flow from religious organization. And presumably this risk is not a necessary feature of law. Consider law in a society of angels as a scenario that Raz himself emphasized in his work. I'll get back to this scenario in a second. For now, we can grant also that law's conformity to the rule of law mitigates this risk of abuse of power. I think that's quite intuitive, right? The rules of a legal system lend themselves to misuse by those in power, by officials, when they're exceedingly specific. Consider bills of attainder that pick out named individuals and criminalize their very existence or impose specific obligations on specific people. Unclear, such as vague constitutional provisions, easily altered. Think of your standard agency regulation, unstable agency regulations, lacking in public justifications. Um, nice example is unexplained shadow docket rulings in the United States. The Supreme Court sometimes rules on cases without telling anyone. um, and applied retroactively, ex post facto laws. This much is extremely intuitive, I think. The question is whether we can find in such facts, granted for the sake of argument, a satisfying explanation for why the rule of law virtues are virtues of law qua law. As Raz puts it, a universal doctrine applying to all legal systems. Now, one way I take it that Raz's explanation is appealing is that it invokes a potential feature of law that mitigating the risk of abuse of power that's both good, right, in a kind independent sense, it's morally good, it's a virtue, it's a good thing, and plausibly related to the specific rule of law features. Indeed, I think Raz succeeds in showing that the rule of law characteristics that are widely recognized aren't an arbitrary set, that there's a principle of unity at work. That said, I think there are serious problems with this proposal. In a nutshell, I think one would expect this explanation to be consistent with the logic of our kind relative evaluations generally. Recall that Raz is trying to explain something people generally think and say about the law. It's not something it's not idiosyncratic to Raz, this claim. And what people generally think and say about the law bears all the markers of kind relative evaluation, as I suggested earlier. And kind relative evaluation, our ordinary talk of what it takes to be a good instance of a kind, appears to be governed by general principles. I'm going to try and persuade you of a few of them. So these criticisms, by the way, are listed number starting on page 2. Right. So firstly, here's a principle that I think is quite plausible. I think it applies to all goodness fixing kinds. You guys can give me a counterexample if there is one. For any x, that is an instance of a goodness fixing kind k with good making feature f, necessarily the fact that x is f makes x a better k if it is a k. To illustrate, telling time is a constitutive virtue of clocks. For any clock, the fact that it tells time accurately necessarily makes it a good clock in a perfectly ordinary sense of good. Put the clock in any possible scenario, in which it is still a clock, mind you, hedging for a reason, and its ability to tell time accurately would make it better as a clock. This much seems extremely intuitive to me, a priori, and conceptually true. Maybe I'm overstating the necessity here, but I encourage you to try out the principle with other goodness fixing kinds, houses, knives, livers, hearts. I myself haven't found a counterexample, but maybe you will. If it's true, if this modal principle is true, one would expect Raz's explanation of law's constitutive virtues to be modally secure, to generalize across possible legal systems, right? But it doesn't. It's not obvious that a legal system's conformity to the rule of law mitigates the risk of abuse of power, not just in the actual world, but in all possible worlds. Consider, again, a world of angels who very much need laws of property, laws of contract, laws of administration. They need to know which side of the road to drive on, even if they lack any need for criminal or tort laws. They have deep respect and reverence for the law, but they still need law, and they have a legal system. Indeed, that's something Raz teaches us. But there's no actual risk of abuse of power in this world for the rule of law virtues to mitigate. Yet the rule of law makes the law better even in this scenario. There may be ways of finessing this issue with counterfactual notions of risk, but that entails complicating the explanation. But we can move on to a more glaring problem. This is the second objection on the handout, which is that Raz's explanatory schema just doesn't work for other goodness fixing kinds. It isn't generally true that the risks entailed by the existence of Ks explains the constitutive standard for evaluating Ks. So to illustrate, the existence of chairs uniquely generates a risk of the risks associated with leading a sedentary lifestyle. But the constitutive standard for evaluating chairs, being comfortable to sit on, is not explainable in terms of such risks, right? On the contrary, kind relative standards of goodness often exacerbate the evils uniquely associated with the kind. Consider knives and stabbings. In fact, I think it turns out to be very difficult to come up with any example, any other kind besides law that works the way Raz proposes. And again, if you can come up with something, I'd be really excited to hear. Such considerations, these examples, this kind of argument from example, I think points to a larger and more general difficulty of locating Raz's explanation within any standard or general theory of goodness fixing kinds. This is my third objection on the handouts, page 3. So, a standard model for explaining the constitutive virtues of at least artifactual and biological kinds invokes the idea of an essential or constitutive function. A clock, for instance, is essentially an artifact that's designed or used for a particular purpose, telling time, which in turn explains intuitively why clocks that don't tell time accurately are bad or defective as clocks. They don't do what clocks are essentially or by their very nature supposed to do. It wouldn't be an exaggeration to say that functions that fix standards of goodness inform our concepts of such kinds. In the case of biological kinds, things are a little trickier, hearts and livers. Here, the concept of an etiological function plays a similar theoretical role. Here, I'm just relying on work by Wright and Millikan. An etiological function is a function derived not from the intentions of agents, but from what natural processes select for or reinforce. The ability to perform some function well explains the proliferation of the kind in question. So, for instance, a heart has the function, the etiological function, of circulating blood, precisely because its ability to do so explains the proliferation of hearts in an environment characterized by various selection pressures. Right? Accordingly, a heart with a clogged artery is a bad or defective qua heart in virtue of its failure to do what hearts are supposed to do given their nature. Again, all this just seems very intuitive. That said, I'm not arguing that we have to embrace, without qualification, a functionalist model, a functionalist explanation of the constitutive virtues of laws. Nor am I suggesting that Raz must have intended his explanation or his claims about law, what makes law good qua law, to fit the functionalist model. The point I'm trying to make, the point I'm trying to illustrate is the various ways that Raz's explanation departs from any general understanding of goodness fixing kinds, right, that has appealed to people. His account can't be justified in functionalist terms. For it's hard to maintain that avoiding abuse of power is an essential or constitutive function of law, whether in the intentional or etiological senses. Take the intentional sense. The countless individuals involved in the design and running of legal institutions often lack the relevant intentions. There are many historical examples of legal systems that were expressly adopted by agents with pre-legal authority, military, economic power, for the express purpose of entrenching their power, reinforcing their own power. It's therefore hard to find a justification for Raz's account in law's intended function, insofar as there is one. It is similarly hard to find a justification in an etiological function for law. It's questionable. It's a questionable, or at the very least unproven, empirical thesis that the proliferation of laws and legal systems is causally explained and sustained by law's ability to mitigate the risk of abuse of power. More plausibly, I think laws. This is an open question, my armchair thought is that laws and legal systems proliferate because of their ability to solve a range of complex problems that arise out of living in community with others. Problems that may or may not include the danger of arbitrary government or abuse of power. But the point is that this is a hard empirical question, right? It's just not obvious that Raz's explanation works in this vein. And in fact, I think it's highly unlikely to work. So finally, and this is the fourth objection on the handout, Raz's explanation seems not to be informed by general principles of existence and persistence that plausibly govern goodness fixing kinds. So it's tempting to suppose that instances of such kinds persist and exist only insofar as they exhibit some minimal, albeit underdetermined, underspecified degree of kind-specific goodness. Their existence and persistence is subject to what Catherine Lindemann has called the threshold requirement. Quite recently, she's written a nice paper on this. What's the evidence? Well, we regularly make claims, I think true claims, like this coffee is so bad it isn't even coffee. That's not true about this coffee, actually. It's unfair use of this example. Or this thing is too blunt to count as a knife. Right? That seems like a natural thing to say. It's often true. And it isn't just ordinary thought and talk that favors the threshold requirement. The principle is entailed by plausible theories of artifactual and biological kinds. I have Amy Thomason's view of artifacts on the handout, her account of what it takes to be an instance of an artifactual kind. I won't read out the complicated necessary condition, but just unpacking the account, just fleshing it out. Her account assumes that the existence of artifacts depends on an intentional act, either an act of creation or deliberate use. Two, that the act must involve an intention to realize in an object some of the essential features of the artifactual kind. And three, and crucially, that the intention should be largely successfully realized, in that the object should exhibit to some degree the relevant features, to some extent. Right? Where the kind relative features include the ability to perform some function well, the successful intention condition more or less entails the threshold requirement. But to make things concrete, to give an example, an object doesn't count as a chair simply because I intend for it to be one. Right? If I have extremely false beliefs about how to make chairs, if I think you just throw a bunch of wood out the window, what I'd end up creating is a mere heap, not a chair. And that's despite my good intentions. Right? So there are very good reasons for accepting the threshold requirement. It conforms to pre-theoretic intuition and it survives the rigors of theory. But Raz's account of the rule of law is inconsistent with it, or at the very least is unable to explain why it should hold in the legal case. For it's unclear why extreme and pervasive abuse of power within a legal system should preclude its very existence or persistence. Now, to be sure, legal systems that govern arbitrarily in ways that violate the rule of law features, say based on the whims of a despot, may be less likely to be accepted, socially accepted or obeyed over time. And that's one way in which they can cease to exist, right? On account of their arbitrariness. Given that on most accounts of the nature of law, a system of rules counts as a legal system. For there to be a legal system, the rules must be socially accepted to some degree. But notice that this would secure a contingent and causal relationship at best between arbitrary government and law's existence. By contrast, the threshold requirement tracks the constitutive and necessary connection between the existence of goodness fixing kinds and the manifestation of kind relative goodness. The way in which a radically blunt piece of scrap metal fails to be a knife, despite the good intentions of an incompetent designer, is non-causal and constitutive. In fact, I'm going to argue shortly that making room for the threshold requirement entails revising Raz's positivist starting points concerning law's nature, but we'll get to it in a moment. For now, I think we can summarize the challenge. We think we've seen enough of the ways that Raz's explanation falls short to set up the challenge. The explanation, one, doesn't clearly generalize across possible worlds and legal systems. Two, appeals to facts that aren't generally explanatory of the constitutive virtues of other goodness fixing kinds. Three, doesn't fit standard and really quite plausible explanatory models that appeal to a kind's intended or etiological function. And four, fails to accommodate a threshold requirement on the existence and persistence of such kinds. Now, I want to say very clearly right at the outset that we needn't assume, before I introduce the view I like, we needn't assume that kind relative evaluation must work the same way for all goodness fixing kinds. But if a kind, such as law, is exceptional in these and other ways, it would be good to know why. It would be good to know how exceptional, and it would be good to know why it's so exceptional. And to my mind, it's entirely unclear why law should be so exceptional. Certainly Raz doesn't tell us. And so I submit that we should at least try to develop a theory of law's virtue, that preserves greater continuity with other goodness fixing kinds. And I'm now going to try to persuade you that we can give a more unified account of kind relative evaluation, though as often is the case, the proof is in the pudding. So we're now on section 3 of the handout, the positive half of the argument. So let's return to the functionalist model, what I call the standard model for explaining kind relative virtue. Recall that for many, maybe all goodness fixing kinds, the kind's function grounds a standard for evaluating its instances. And not just any function, mind you, an essential or constitutive function. I emphasize this because there is a sense of the term function that tracks even one-off uses to which an object might be put. But cutting things is plausibly essential to our concept of a knife, or our concept of what it takes to be a knife, And this function, not just any old use to which a knife might be put, plausibly explains the constitutive virtues of knives. Virtue of knives, being good at cutting things or sharpness. Likewise, what makes a flathead screwdriver good as a screwdriver is its effectiveness at turning screws. Even if the statistically dominant use of the tool is to pry things open, that's certainly the dominant use in my household. It isn't true that being good at prying things open makes something good qua screwdriver. Right? So, if law has an essential function, a constitutive function, we might be able to explain the constitutive standard for evaluating laws by leveraging a perfectly general phenomenon associated with functional kinds. And in fact, there have been some attempts to explain the rule of law in functionalist terms. Both Lon Fuller in his classic discussion of the morality of law and my colleague Andre Marmer more recently have tried to argue that law has the essential function of roughly guiding people's behavior, and that the rule of law features like clarity and non-retroactivity are good-making features of law precisely because they make the law good at realizing this function. The law is better able to guide people's conduct if it instantiates these features. Now, I obviously think the general strategy is promising. I'll pursue it myself, but these specific proposals, I think, confront serious problems. First, it's not obvious what justifies the attribution to law of this essential function of guiding people's conduct, or indeed any function. Andre will get upset at me for saying this, but I'm not sure he's entirely clear on the basis for function attribution. And Fuller, I think, is even less clear. Second, even if we grant that law essentially aims to guide people's behavior, to guide conduct, the same could be said about the rules of social clubs, the rules of etiquette, the rules of criminal organization, the rules of religion. But the rule of law is not so obviously a constitutive virtue of these other forms of social organization. Third, even if some rule of law features like clarity and non-retroactivity necessarily augment law's ability to guide people's behavior, it's not at all obvious that the other relevant virtues have the same relationship to the function, such as generality or even publicity. Right? I fail to see why bills of attainder that pick out named individuals and impose specific obligations on them in one-off situations can't be action guiding. Of course, they can be action guiding. The same is true of rules that lack public justifications. They've historically been accepted and followed. Right? Third, and most importantly, I think, even if we were to assume that the rule of law virtues, features together or individually render law more likely to perform its action guiding function, this unfortunately would not result in the kind of explanation we're after. And this is because not every characteristic that improves goodness fixing kind's ability to perform its essential function counts as a constitutive virtue. It's easily illustrated. A clock that requires substantial quantities of energy to function is less likely to tell time accurately, at least in our world. But being energy efficient is not a constitutive virtue of clocks. Put differently, there are possible situations where such clocks work perfectly well, right? In energy abundant worlds. So the core challenge for the functionalist is to specify a suitable function, explain why law has the relevant function essentially or constitutively, and finally explain how this function relates to the specific rule of law features. And this challenge is what I propose to take on next. One of the benefits, I think, of making all this clear is that it can help us make progress on more traditional questions in jurisprudence. So we're now on page 4 of the handout under law's acceptance under the guise of the good. So as a first step, and I'll speed up here in the interest of time, we need to clarify the basis for attributing law to law an essential function, or the basis for thinking of law as a functional kind. Now, most theorists, I take it, agree that the existence of law in legal systems depends, at least partly, on the social acceptance of rules. So there's a social criteria for the existence of legal systems. Rules must be, to some extent, socially accepted. Moreover, a recurring theme in the literature is that what distinguishes legal rules from the rules of etiquette, clubs, and other forms of social organization is that law elicits a form of social acceptance that's fraught with normative assumption. Raz provides a famous illustration at this point. He maintains that law necessarily claims authority over its subjects, and a natural interpretation of Raz's authority thesis is that this claim is a claim that legal officials and other members of the community make on behalf of the law. Right? These members of the community must regard the rules of social organization in a certain way for there to be a legal system, namely, as rules that give people genuine and potentially decisive normative reasons for compliance. A similar idea is implicit in Scott Shapiro's suggestion that what distinguishes legal rules from the rules of a criminal organization is that only the former are essentially presented and accepted by officials as having a moral aim, roughly that of solving various moral problems associated with living in community with others. And by the way, the authority thesis, the moral aim thesis, similar theses are usually are justified or motivated based on extensional considerations. Right? We want our theory of law to adequately distinguish law from other normative systems. But it's also intuitive. It's also supported by actual legal systems. Most actual legal systems have I can't think of one that doesn't, a justifying narrative, right? Some sort of explanation for why it's justified. Um, Even Hart's famous thesis that the existence of a legal system depends on officials taking the internal point of view on a set of rules is naturally, even if not uncontroversially, understood in terms of normative attitudes. Taking the internal point of view on the rules involves thinking that there are reasons for obeying and enforcing them, reasons that may give rise to an obligation, but needn't. So we can distill from these various claims a unifying principle of clearly broad appeal, namely that the intentions of agents that ground law's existence are characterizing intentions. Legal rules are essentially rules that are accepted, chosen, enforced, obeyed as N, where N could be any property, like having authority. Recall that such characterizing intentions play several important roles in the case of ordinary artifactual kinds, like clocks and knives. For one, they inform our concept of the kind and its essential function. A knife is essentially an object that's designed or used as an object for cutting things. Additionally, characterizing intentions determine whether some object counts as an instance of the kind. A sharp object counts as a knife only if someone more or less successfully intends it as a tool for cutting things. Hence, if the mode of social acceptance that grounds law's existence similarly involves some shared collective assumptions about the character of the accepted rules, we may be able to derive from this characterization an intended function for law and in turn an explanation for the rule of law. We can rule out immediately certain possibilities regarding the nature of this property. So suppose that being N is just the complex conjunctive property constituted by the specific rule of law features, being general and non-retroactive and public and so on. If so, then a system of rules would count as a legal system only if it is accepted for the express purpose of establishing a social order that is clear, non-retroactive, public, and so on. But that's highly implausible. Right? It's highly unlikely that legal systems exist only when agents have these complex intentions. Indeed, there are plenty of legal systems that have existed in the absence of such complex intentions. Note that we're trying to identify the shared content of a group intention, the kind of intention that results in something as complicated as a legal system, and so these group intentions are rarely that specific. Right? That seems true. A more likely scenario is that being N is a very general normative property with a non-obvious constitutive connection to specific rule of law features. There are at least two reasons why this property is likely normative in nature. The first we've already noted. There are independent grounds for thinking some normative assumptions are essential to law, such as having authority or being conducive to the general good. The second reason builds on a point that I've now made in a few different ways. The relationship between being N, this property that's essentially attributed to law and its social acceptance, and being general good, public, and so on, cannot be merely causal and contingent, or else we'll run into the same problems we encountered earlier. If the generality and publicity of the laws merely makes it more likely that the law performs its essential function, this won't be sufficient to explain the virtues of law as law. The connection must be non-causal and constitutive. And I can think of no non-normative property that's constituted by the specific rule of law virtues. Whereas it is very tempting to think that there is some normative ideal, perhaps an ideal of fairness, perhaps an ideal of reasonableness, rationality, whose realization constitutively requires general, clear, public, non-retroactive rules of social organization, an ideal that legalistic societies may be especially attuned to. And so it is tempting to suppose that law is, by its very nature, socially accepted as a mechanism for realizing a singular normative ideal that we might call, without begging too many questions, hopefully, the ideal of the rule of law. Okay? So let me take stock, I'm gonna since we're almost at 45 minutes, I'll mostly end here. Just summarize some implications. So I've argued that a satisfying explanation of law's own virtue may be found in the fact that the existence of law depends on rules being accepted by members of a community as rules that realize a normative ideal. This fact about law explains, in the usual standard way for artifactual kinds, laws defining or constitutive function. Legal orders aim at the relevant normative ideal, and law's function in turn explains, again in the standard way, the constitutive standard for evaluating laws, the rule of law, so long as this normative ideal's realization constitutively depends on the realization of a social order that exhibits the rule of law features. Now, granted, I've left the ideal underspecified, but the aim was to develop a general explanatory schema, one that meaningfully constrains our account of the nature of law. And here I will just summarize some of the implications. In the paper, I argue that this view has two implications, two important implications for jurisprudence. One is that the attitudes, these normative attitudes that condition law's existence, must be sincerely held. If they're insincere, our explanation of the rule of law won't work. And that rules out certain ways of construing Shapiro's moral aim thesis, Raz's authority thesis, in particular, David Plunkett's fictionalist construal. And another implication of this view concerns the threshold requirement. Right? Earlier, I talked about the intuitive, uh, the sort of plausible general truth about goodness fixing kinds, that their existence depends on their instances exhibiting a minimal degree of kind-specific goodness. Um, Applied to law, it means that legal systems, the existence of legal systems depends on the social rules meeting to some degree the normative ideal. Um, and that entails a weak form of non-positivism. It entails conceding some ground to non-positivists. And that's a big deal. Okay, I'll stop there.